Hi, I'm George Pino, the CEO of Commercial Brokers International, and some of you may recognize this young man here, Scott Mayer. So Scott's a real estate attorney located here in Los Angeles with experience throughout the state, as well as I think a couple other states as well. And, I brought him in and asked, and we've been doing a series on some of the legal issues when it comes to commercial real estate and real estate in general. But I asked him to come in today specifically so we could talk a little bit about one of the top questions I always get from my clients when I tell them, we're about to enter escrow, let's make sure we have our team in place. And when they ask me who the team is, I tell them exactly who I'm looking for, and I say, who's your real estate attorney? I can tell you that more than half the time I probably get do I need a real estate attorney? And, I always say I recommend one, and at the very least to review certain things. And I have some clients that will only, maybe take a smaller role or have the attorney take a smaller role and just review like the PSA, purchase and sale agreement, as well as some of the other documents, but not really help or do anything along the negotiation side. So I thought, I know what my top reasons are why someone should have an attorney and why both parties should have legal representation. What do you tell your clients? How do you explain that?
So George, let me start out by saying I've been on both sides. Mm-hmm. I've been a real estate attorney for 30 plus years, but I've also been a developer. Mm-hmm. I've been the president of a development company. So I've been on both sides as a counselor and as a principal. And I will tell you, when I have been a principal in a commercial real estate transaction, there are always issues that come up that I know that if I wasn't a real estate attorney, I wouldn't have the knowledge or the experience or the expertise to respond to them. Mm-hmm. And that's not a good way to approach a transaction. If you don't know something, just to let it go. That's why you need competent advice. Mm-hmm. And in a commercial transaction, there are all sorts of documents, agreements, whether they be the purchase and sale agreement, it might be a lease, it might be loan documents, mm-hmm. It could be due diligence, such as an environmental report, a title or survey, and all those documents include information that is not generally known, even to sophisticated real estate mm-hmm. people. They need someone to provide legal advice and counsel.
Well, and also to be frank with you, a lot of my experience is that a lot of those documents not only are they there to be explained, but they're there for the attorney to help negotiate.
Correct.
When we talk about things like if you're getting a loan, the lender's probably going to require an SNDA. The lender has a specific form, but a lot of times the lease may already have an attached form. So you have to go in and start negotiating and understanding what language can affect that SNDA and work with both the lender, the seller, the buyer, and the tenant to get a form that's acceptable to everybody to sign. So, and a broker really can't do that, I don't think. I think in theory, yes. I mean, but realistically, I think having an attorney to really explain, because literally one word, especially if you're not even in, some of my clients, they buy out of state all the time. And if you're out of California, I know for a fact I can't give any kind of advice on the legal aspects of what's going on in that particular state. While I can probably give enough advice in California to get myself in trouble, but definitely not out of state. So we always have, we always work with different attorneys, and sometimes even the attorney that a buyer has, if they're buying something out of state, they may need to have local counsel as well.
Correct, because I'm, for example, licensed in the state of California. I'm not permitted to practice law in any other state in the union. Mm-hmm. But going, back to your point, in a commercial environment, whether it be loan documents, whether it be a purchase and sale agreement, whether it be a lease, there's always negotiation. Mm-hmm. Unlike residential transactions where forms are generally used for a purchase contract or for a lease, and they're generally not negotiable. But in a commercial situation, they are negotiable, and so you really need to have not just a real estate attorney, but a real estate attorney that has experience dealing with the particular document or the particular transaction. Because while we might hold ourselves out as real estate attorneys, it's a vast field. And for example, there are certain things in real estate that I feel very comfortable with. Acquisitions, dispositions, leasing, and finance. But that's because I've been at this for 30 years. But
Absolutely.
There are some attorneys who, for example, don't have any experience with loan documents, but they hold themselves out as real estate lawyers. And so it's important for people to, when they're looking for a lawyer, to ask questions. How long have you been doing this? What sorts of transactions have you been involved with? Do you have referrals?
Absolutely, and I think one of the things you mentioned, even loan documents, a lot of people, even on the commercial side, you'd be surprised how many of my clients on acquisitions are, I can negotiate the loan documents, and there are typically, even on a non-recourse loan, there's what they call bad boy clauses, where if they've lied about it, they could still be in default and be, now that triggers a liability for a guarantee potentially. But even negotiating the amount of that guarantee, all kinds of things can be negotiated, or carving out what may be considered a bad boy clause. And I think that's something that attorneys see this a lot more than the brokers, because the brokers really don't deal with that aspect of it. So they're going to have a lot more experience with that. So that's, looking at it, what I always recommend to my client, at the very least, the transactional documents, and maybe a abstracting of the lease, where they can actually just give, here's a couple things to be aware of, or just note, and of course the loan documents and the closing paperwork, the assignment paperwork, making sure that it's done correctly, the assignment of the leases, where it's going, how it's done, notifications, all of that. I've had some clients, though, that have also said, yes, I want an attorney involved, but I don't care, they don't need to review the PSA, because as long as I have an out in 30 days,
yes,
I'm good. And so as long as they have a due diligence period where they have an absolute right to cancel, some clients are okay with just going that forward. I personally like to see them involved, the attorneys involved a little bit, because I think that attorneys can also bring another layer of negotiation. A lot of times as a broker, I have found that, and trying to negotiate something with another broker or with the seller or the buyer, there are a lot of times emotions that may be involved.
Yes.
And because of that, it gets heated, and if you're the listing agent is pushing and pushing and pushing to close. The buyer's agent, for even if they are trying to close and there are things out of their control, may not be able to, they're trying to buy more time so they're not really co-aligned in trying to get the ultimately closed, yes, but not on time frame wise. So I had a situation like this before, where both the listing agent, I was representing the buyer, and myself, we both agreed that we needed more time, but his client was being very difficult about extending the PSA, even though logically it made perfect sense for him to do so on every front.
Yes.
And ultimately, we were gonna end up canceling the transaction, but as a last-ditch effort, I reached out to the buyer's attorney and said, can you contact the seller's attorney and explain this? And sure enough, within 2 hours, done.
Good.
So it was a nice negotiation, because it brought in a third party that the other principal trusted to give advice. They came back and said, no, this makes perfect sense.
Well, attorneys sometimes, especially in the real estate world, are unfortunately known as deal killers.
Yes.
And a good real estate attorney will not kill a deal, but he will or she will have enough experience to know how far to push a negotiation. because ultimately the attorney is representing the client. The attorney is not the principal in the deal.
Yeah.
We are just here to provide, necessary and quality counsel to our clients.
Well, that brings up an interesting question, and I'll probably end it with this one. But do you think that there are some attorneys out there that may overprotect their clients? And the reason I say this, is, one of the hurdles to getting a client to hire an attorney sometimes, when they haven't used them before in a real estate transaction, is that they think they're going to be nickel and dime. There's going to be fees and fees and fees.
Yeah.
And there are a lot of times I've noticed that in lease negotiations, especially, because purchase and sale agreements are relatively straightforward, but leases you can negotiate just about everything for long term, and I've noticed that there are certain attorneys that are out there that we've either come across or dealt with that over negotiate to the point where I've literally gotten on the phone on a conference call and said, I understand that this is in their best interest, but in your 20 years of experience, have you ever seen this happen? And usually when I say something like that, I'm usually pretty sure they haven't. And usually they come back as no. So I think it's really important for attorneys to be able to explain the actual risk. If like, what are our talking points? What are our negotiating points? What can we keep? And what are we going to use to negotiate and throw away?
So here's a hint. The party that produces the document, whether it be a lease or a purchase and sale agreement or the loan documents, has a form that is protective of their client.
Yeah.
So let's take a commercial lease, for example. If I'm representing the landlord, I have a landlord-oriented form.
Mm-hmm.
If I'm representing a tenant, I have a tenant-oriented form. And through all of my experience, I've been able to develop both.
Mm-hmm.
And if the other side doesn't have an attorney, they don't realize that maybe I can negotiate that landlord-oriented form to something that's maybe more neutral or more in my favor.
Yeah.
It's, if you don't ask, you're not going to get it. You're not going to get it. I'll give this example. There's a well-known landlord in Orange County who has different, it's the same lease, but they have different versions of it. And they'll start out giving you the landlord-oriented form. It's a really difficult document.
Yeah.
And then you start negotiating with them, and then they give you the second one. And then ultimately, if you're smart enough and have enough experience to bring up valid points but not kill the deal, they'll give you the third form. But
Yeah.
you have to, if you don't have an attorney, you're going to get probably stuck with the first form and never get to the more tenant-friendly form.
Yeah, and to your point, I actually have different attorneys that I like to use depending on the type of transaction.
Yes.
Because for instance, I have, and also potentially for who the other landlord is, because I know some attorneys, like for instance, they've dealt with different REITs like Douglas Emmett, and they know what can be negotiated and what are hard stances on their part.
Yes.
So if they have the experience with them already, they're going to save the client money, and they're going to be able to explain that, as opposed to having an attorney that's going to come in, give a red line on that 90% is not accepted, and that's just ruining. And then people are going to get upset too. The client's going to get upset saying, well, why didn't they accept all this? I thought you said this was to protect me and make me as reasonable. And so, it gets in that situation. But, ultimately, I'm going to leave it with this. If every institutional investor out there is using an attorney, and it's to protect themselves and their investment, if you're making an investment for your retirement or your personal or your family, I think it's probably a good idea to have an attorney there as well to help protect it for the long term. Okay? So if you'd like any more information and contact, I'm going to have Scott's contact down below here. Please feel free to reach out at any time to either himself or myself. I look forward to seeing you at the next one. Thanks.
Thank you.